Good afternoon again, everyone. This is Jeff Jenkins, the senior partner at Jenkins and Clayman, one of New Jersey's premier bankruptcy firms. And we're here today to talk about a popular and interesting subject. And before I get into that, my partner Eric just called me and he's having a little bit of car trouble. So hopefully he'll be here soon, but if not, you can put up with me, I guess. So today we're going to be talking about what happens if you get married and one of the spouses has certain debts. Do the other spouse somehow absorb these things just because by virtue of the fact that you're married? A lot of people get puzzled about that. And we're going to talk about that. What if one spouse dies, or is the other one responsible for the debts? And we want to talk about co-signing loans too. And these are very important topics, and a lot of people are not sure what the answers are, and Eric and I get asked these things frequently. So Eric just arrived.
Hi, everybody. Hey, Jeff, how are you today?
Good.
Sorry I'm late.
It's okay.
A little issues. Issues resolved. So
I think I look better with you sitting here because you're screening the light from me.
Sharp. Yeah. I get all that sun right on me to block you, make you look better. That's our goal.
Yeah. So I just kind of introduced things so far, and haven't really started talking about anything except generally what the topic is.
Right. And Jeff, I guess when we talked about this yesterday, prepping as we prep hours and hours for today's session, the one line that I did want to mention was, anytime we use the word cosigner, when a client calls and uses the word cosigner, we always say there is no such thing in a lot of ways, because you're just as responsible as the other person who's signing it. We get so many parents who say, I co-signed this car for my son and my son lost his job, but he's got to pay. Well, now you have to pay. And you have to anticipate every time you choose to co-sign, you have to anticipate that the other person is not going to make the payments. You can do it. And there are some parents with tremendous financial means that it doesn't matter if they co-sign for their son's car loan. But unless you're one of them, you have to be very, very thoughtful before you co-sign for a friend or family member.
Yeah, that's a very good point. We do have a lot of clients that come in and they say, well, I'm just a co-signer. Like they're safe somehow because they're just a co-signer. In fact, they're a signer, just like the other person is a signer. And the liability is joint and several. That means that each person owes the entire thing. And that's just a good thing to keep in mind. And if you're thinking about co-signing something for somebody, you need to think long and hard, because you never know what's going to happen. And if they fall behind, your credit's going to be affected too, adversely affected.
And the good news is, Jeff, that we help people for over 30 years who've co-signed for debts.
Yeah.
And just as it's your responsibility as a co-signer, it's also our responsibility as your bankruptcy lawyers to get you out of that debt. And if you call 856-546-9696, we can help you right away. If you've co-signed a debt and you remain responsible for that debt, probably have other debt problems, you might just have questions about it. Give us a call.
Yeah, when we have clients in, we go through everything, and everything includes, are there any co-signers on any of your debts? And if there are, we need to talk about how you want to treat that debt. Now, if it's a couple that's breaking up and we're representing the wife and the husband's a co-signer on something, and we say, well, what about the fact that he's a co-signer? Do you care about that? No. But then other people, well, my mother's a co-signer and I do care. I don't want anything to happen to her. And whatever way you want to do it, we can structure things so that it happens that way. We can keep creditors away from co-signers or let them go after the co-signers, just depending on what kind of bankruptcy we do, what kind of plan we have, and so forth.
And that's something that a less experienced bankruptcy lawyer wouldn't know about, Jeff. Many practitioners general practitioners who dabble in bankruptcy will just throw people into Chapter 7. And the person who files bankruptcy gets rid of the debt, but the mother, who had no responsibility for the debt other than the fact she signed it, remains liable. And it makes everybody, it's a lose-lose situation.
Yeah.
But as a law firm who handles all consumer bankruptcy problems, including, or find solutions, including the solution of Chapter 13, it's an interesting code section, 1301. It's interesting they put it on the beginning of 1301.
They probably deleted what used to be there.
Instead, just jammed it in, right? It doesn't make sense. That would be the first law in
Okay,
Chapter 13.
yeah.
But Jeff, you can go ahead. Tell us about 1301, because it is
Okay,
fascinating.
well, that's one thing that Eric and I wanted to talk about. And in the bankruptcies that we do for people, generally we're just doing a Chapter 7 where you don't pay anything back on your debts. You're erasing erasable debts. That's it. At Chapter 13, we will usually do, for many reasons, we would do one or the other, but the normal reason in Chapter 13 is you're behind on something you want to keep. So you need a paying kind of bankruptcy, like you're behind on your mortgage, you're behind on your rent, you're behind on car loan. We need to do a paying kind of bankruptcy. And one section that's peculiar to Chapter 13, and you don't find it, actually they do have one in Chapter 12. I mean, we never do a Chapter 12 that's bankruptcy for a farmer. There's not a lot, well, I guess there are farmers in South Jersey, but we usually think about it in terms of being a Chapter 13 section, and certainly Section 1301 is. And what it says is, if there's a cosigner on a consumer debt and you do a Chapter 13, they're protected just like you are from the creditors. The creditors can't do anything to them unless they get the bankruptcy court's permission. And we can do different things. Like I said, we can not treat them specially, in which event, if the creditor goes into court and says, I want to go after the cosigner, the court would let them. Or we could offer to pay them 100%, even if we're paying other creditors nothing. Because in the bankruptcy code, it says you can create separate classes of creditors, and you can have a cosigner class, and you can treat it differently from all your other creditors. So maybe your mom co-signed on your car, and you're going to pay for the car completely through the bankruptcy. You owe $10,000. Well, we can pay that, and we don't have to pay the other unsecured creditors anything, assuming there's no co-signers involved in the other debts. And that way, the car company will stay away from your mother. When you finish the bankruptcy, you're both going to be absolved of that debt. It's going to be gone because you paid for it, and now the car is yours.
And at the same time, all the other credit card debt, medical bills, personal loans, payday loans that you have, for most clients, will be completely wiped out.
That's right. That's right.
Because if someone has a cosign debt like that they're trying to protect the mother, chances are that was a debt they tried to pay really hard and they couldn't. So they probably have a lot of other debts.
Yeah.
And that's what we're saying. Look, we have people who call us good, hardworking people. A lot of times they have that second or the third child. Or a lot of times what we're hearing about is the coronavirus people, that the kids are not going to school long enough. One spouse has to stay home, and 30 to 50% of income is down.
Yeah.
So guess what? We use credit cards to make up the difference, but eventually you can't. And what we do is when someone calls us and we say, hey, if we can get rid of your credit card debts, can you pay your mortgage? Yes. Can you pay for both car loans? No, but I can pay for one. And we work with you and see what we can do to make sure that you won't have shelter anxiety, food anxiety, utility anxiety. You come in with difficult situations, but you walk out of our office. It's figuratively walking out of our office with a solution. And that's what we're here for.
Right. Eric, let me just go back to kind of the beginning and talk about what if you have a spouse and the spouse dies. Does the spouse's debt become yours somehow? No, it doesn't. It's not like a cold. You catch it if you're around somebody all the time. If those are your spouse's debts and not yours, and the spouse passes away, it does not become your liability, but it does become a liability of your spouse's estate. And if there's any value to the estate, you need to be concerned about those kinds of things.
Right. It gets a little bit confusing. But just because your spouse died, and if it's his credit card debt or his car loan that you no longer want to pay for, they can't ask you for the money just because you're married unless you sign something. But where Jeff is going, and this is where it gets a little bit more complicated, is what other assets did the spouse who died have? And you do have the obligation to liquidate those assets for the benefit of creditors.
Yeah. For a lot of people, what their major asset is going to be their home. And if you've got a married couple, a lot of times both people are going to be on the deed, the husband and the wife. They're going to buy it jointly. And they're each going to have an undivided interest in half of the property, but there's a right of survivorship there, meaning if one spouse passes away, the other spouse gets the whole property by operation of law. So it does not pass through the estate. The spouse who died, we were talking about that, that spouse's part of the property does not become bait for the creditors. It passes automatically outside the estate to the other spouse because of the way you took title to it.
And Jeff, as we talked in preparation for today, and I want to interject this, and then you can go to the other example. The other example of something that would pass without going through the estate would be perhaps life insurance with a beneficiary and retirement accounts with a beneficiary listed like that.
And so just thinking about that whole thing, making a retirement account or a life insurance policy, and you're going to put down who the beneficiaries are, you really don't want to put the decedent's estate, because then it becomes property of the estate that creditors could latch onto conceivably. You want to have it go to a person so that it passes outside the estate and away from the creditors, whether it's life insurance or an annuity or whatever. When we do a Chapter 13, and you've got a car loan, sometimes, and in fact, any kind of loan, a furniture loan, car loan, what else?
I don't want to say student loans, but they are also, but
We're going to talk about that.
That's a different category. So you do have people who have co-signed on credit cards and car loans. I think that's a good example, Jeff. Those are the two.
But what we wanted to talk about was if we don't have a co-signer on a car loan, and the car is of a certain age, more than 2.5 years, you've had it for more than 2.5 years, we call it cram it down. We can pay the value of the vehicle plus interest through the bankruptcy, and the balance that you owe would be treated as an unsecured debt, like a medical bill or credit cards, and we can just erase it. We couldn't do that, of course, if there was a co-signer on the car, because then they would be liable for whatever portion wasn't paid through the bankruptcy.
Real quick, you come to see us, you have a lot of financial problems, including your car, and your car is a burden. You want to keep your car, you have to keep your car. But as Jeff said, if you've had the car for 2.5 years or more, I like doing this, cram it down to value. So if the car's worth $8,000 and you owe $12,000, you only have to pay the $8,000. And Jeff, when that happens, clients are so happy because we say, no, you're not paying $450 a month, you're going to pay $250 a month.
Yeah.
And it's really, we get good results in those cram down cases. But this is another perfect example for co-debtor, because you can't do that kind of cram down.
Right. Yeah. So we're not only decreasing what you owe in the car by cramming it down, normally we're also decreasing the interest rate.
Yes.
And probably extending the term of the loan. So your monthly payments are going to be generally much less than they were before, which is a good thing.
No one wants to file bankruptcy, but if you're going to file bankruptcy, Jeff and I are going to do everything that we can to make your payments as light as possible and to make sure you'll keep every asset you want to keep. That's our goal. make your either get rid of the debts completely through Chapter 7 or restructure your debts under Chapter 13, as Jeff said earlier today. If you need a payment type bankruptcy because you're behind with something you want to keep, we're going to make your payments as low as legally possible, and you're going to keep every asset you want to keep. And that's very important. Plus, you're getting rid of credit cards, medical, personal loans, restructuring the IRS, restructuring car loans. There's a lot we can do.
Yeah, and that's very important, Eric. And we do make a big point of talking to our clients about their various assets and do they want to keep them or get rid of them. And if you want to keep it, we're going to make sure that you can keep it. We're going to do whatever we need to do to make sure that you keep that asset. So sometimes people say, well, if I file bankruptcy, can I keep my car? Can I keep my house? Can I keep this? Can I keep that? We can do whatever you want. If you want to keep stuff, we can make sure that that's what happens.
Absolutely.
Yeah. Want to talk about student loans?
That's complicated. Now, if you want,
taxes are complicated.
Taxes are complicated too. I might left yet, but last week we had a nice 20-minute discussion about student loans. So if someone's interest is piqued by today's discussion on co-debtors, but didn't see our video from last week and have student loan issues, I'd suggest that you go on the Jenkins Clayman website and you can look under videos and check out the last video on student loans. It's only 20 minutes and you'll really learn a lot about what's available to help you with student loans. But today's episode deals with co-signers, and we see co-signers on student loans all the time, don't we?
Yeah, the lovely student loan people, that's what they want to do. They want to get as many people signed up for the loan as possible.
Right.
I mean, throughout our 30, 35 years of doing this, actually, it was January 1st this year was the 35th anniversary of our firm. Because I started January 1st, 1986. Yep. Anyway, with student loans and any kind of loan, I've had people say, well, I've got a mortgage loan and they had my uncle co-sign. Can't they just let him off? Never. They're not going to do that. They've got your uncle on the hook for the loan. They're not going to let him go. And the same would be true of student loans. If they can get your grandmother to co-sign, your parents, whoever, they're not going to change that. It's just not going to change. But if you've got problems with student loans, and Eric's right, we talked about this a lot last week, and you can certainly, if you're really interested in student loans and you didn't listen to last week's program, it would be worth your while to do that. But when we file a Chapter 13 and our client has student loans, whatever we do with them, the co-signers are protected because is a student loan a consumer debt? Remember I said that for Section 1301 to apply, you've got to have a co-signer on a consumer debt. And is a student loan a consumer debt? Most courts have said yes. It kind of depends on the type of education that it paid for and some other things, but generally student loans are considered consumer debts. And so if we file Chapter 13, your poor grandmother who had to co-sign or else you couldn't go to school is going to be protected just like you will, even if you don't pay them anything during the course of the plan. How about tax returns?
No, this is interesting because a lot of times our clients will, as Jeff talked about owning a home, let's back up. Also in tax returns, most married couples file joint tax returns. You're supposed to in most situations, and most do. But a lot of times people see us and only one spouse has severe financial difficulty, so severe that they have to file bankruptcy, and they want to protect the other spouse's credit. So one spouse files, but there's an IRS debt. This is where it becomes complicated. The moment you file bankruptcy, the spouse who files bankruptcy is certainly protected from the IRS from all collection actions. But is there a co-debtor status to the IRS for the non-debtor spouse who co-signed the tax return? And the answer is no, just because of what Jeff said. Section 1301 applies to consumer debts, and the IRS tax debt is not a consumer debt. So you have a situation where we sometimes can talk to the IRS, and if the client is paying withholding taxes, the spouse, the non-filing spouses, they may leave the debtor alone. They may leave the debtor's spouse alone. But to add a further level of complication, if you're doing the payment type bankruptcy, the Chapter 13, or the Chapter 7, let's talk first. If the tax is more than 3 years old and has been in the IRS's hands for 2 years or more, and we can talk to you about the specifics here. Even in a Chapter 7 no payment bankruptcy, that debt gets wiped out. In a Chapter 13, that debt gets wiped out. If the tax is less than 3 years old, or the IRS hasn't had, basically, if the tax is less than 3 years old, it can be paid back in a Chapter 13, no penalties, and interest is stopped. Well, that's great for the husband who filed bankruptcy. But Jeff, what happens during the 5-year Chapter 13 period for the wife who didn't file bankruptcy?
Well, unfortunately, is the non-filing spouse, in this case the wife, she owes the taxes just like the husband does. And so he's doing a Chapter 13, penalties get dropped away, interest stops until he gets it paid back, but none of that stuff happens for his wife. The interest continues to run. The penalties are still there. So he might get rid of a lot of the debt, but when he finishes his Chapter 13, they're going to send the wife a notice that says, your husband got rid of a lot of what was owed, but you still owe a lot of it. So this is how much we want you to pay us.
5 years worth of interest can add up. Now look, if it's a $5,000 IRS debt, generally I would say at the end of the 5 years, the non-filing spouse will probably owe $1,500. It's not going to kill you because the principal part of the debt will be paid back by the person in Chapter 13. But if it's and we've had clients with plans to pay back $50,000 over 5 years.
Yeah.
And if the spouse doesn't file and they're still married, at the end of that 5 years, the client says, yes, I don't owe the IRS any money. No, my wife still owes $15,000 probably.
And that's one of the things that we deal with. We get something. We're going to do everything we can to convince them that both of them file the bankruptcy. Because when you do a bankruptcy, to have things cleaned up for one spouse and not for the other doesn't make a lot of sense because there's still debt weighing that couple down after the bankruptcy is over with. If you get both of them to file a bankruptcy, then we can clean everything up. And then you get a real fresh start, both of you. Debts are gone, you can live a good life, go on with your life.
We've had many success stories, and we actually had an episode about success stories. But we've had people owning homes, boats, motorcycles. After the bankruptcy, you can get a fresh start a new business, do whatever you want to do. We'll get you there. That's been the theme of today's episode, Jeff, is that there's a lot of word they're using in this past couple of years. There's a lot of optionality in bankruptcy.
I've not heard that one.
There's a lot of optionality. And if are you serious? It's a newer word, optionality. And
I've heard about reimagining things.
You can reimagine, which seems redundant, doesn't it? There's a lot of optionality. And if you deal with an attorney who dabbles in bankruptcy, I can't believe they're going to be aware of all of your options. Furthermore, if you deal with an attorney who's by himself or herself and doesn't have the ability to talk about ideas and be kept up to date with a law partner in a law firm, you run a risk as well.
Yeah.
If you deal with us, you're dealing with 4 attorneys who do nothing but practice consumer bankruptcy, and we're here to help.
And taxes are very complicated. Probably one of the most complicated things that we have in a bankruptcy. And Eric and I are both certified by the New Jersey and Pennsylvania accountancy boards to be instructors for accountants. And if they go to one of our classes, they can get continuing education credits. So we know about taxes and other things about bankruptcy too.
And we pay our taxes too.
That's right. We do that. Okay, I think that was pretty good coverage of our subject.
I think so too. So my car didn't start, basically, everybody, after lunch. And I don't know why, but fortunately, my brother-in-law, shout out to Yoav, jump-started it. And they needed 2 jump starters, one for the trunk and one for the front. If you know cars, you'll know what kind of car I have. If I can tell you, needed 2 jump starters. But I'm back, and all is well.
Yep. So we'll see you next week, same time, same place, 2 o'clock Thursday afternoon. not sure what we're going to talk about yet, but it'll be something interesting. We can guarantee that.
Yes.
So goodbye until next week. Take care. Be safe.